Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws 2. In this edition, we look at DWI cases, and not the DWI where the person took a breath test, but where there's a blood test that was done. Now, automobiles are in the area protected by the Fourth Amendment to the United States Constitution, and so there can't be such a thing as a random stop, and the state must prove that there was some type of probable cause to take the blood samples. Let's say, now, oftentimes where there's a blood test done, it's either because there's an accident and the person was not able to give breath samples, or where they did give breath samples and there was a zero reading, but the police had reason to believe that the person was under the influence of some type of drug where they did a blood test. So let's say a blood test is done. Let's say, what are some of the possible defenses that the defense counsel may do? Let's see. Well, number one, a suppression motion is filed to suppress the seizure of evidence. Two, the defense counsel can object to the entry of any report by the nurse or lab or person who took the blood under the State versus Crawford. The prosecutor should be required to show any blood specimen was obtained in a medically acceptable manner and object to just simply a notarized statement. Three, the prosecutor and state need to prove that there was a chain of custody. Therefore, they have to show that once the blood was drawn by the person at the hospital, that who handled the blood along the way, the different police officers that eventually took the blood to either the state police lab or whichever lab conducted the analysis of the blood. Four, let's see, a lab report should not be routinely admitted when there is a formal written objection to the lab certificate. In criminal cases, under NJSA 2C:35-19, I'd say also the objection in motor vehicle and DWI cases is under State versus Crawford, State versus Berezanski, and certain other cases. I'd say, now another objection to the lab report is based upon the defense request that the gas chromatography results be provided, and that is based upon the case of State versus Weller, 225 NJ Super 274. Now, even if the gas chromatograph results are provided, there's still a requirement based upon Berezanski and Crawford that the chemist who did the analysis of the blood still be brought in. Now, there is case law that a physician-client privilege does not apply, but there still should be an objection by defense counsel that the taking of the blood, let's say by the doctor and given to the police, violated the person's patient-physician privilege. Let's see, and if it was obtained without a subpoena, well, that's typically improper. For other like ideas and information on fighting a DWI or other case where blood is drawn, visit the articles we have on website njlaws.com. That's www.njlaws.com, and also benotguilty.com. That's benotguilty.com. For other information, call the law office of Kenneth Vercammen, 732-572-0500. They're located at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you and good luck.